Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis, and today I'm going to go over a MEE bar exam essay with the goal of going over a few different things that are important when we talk about essay construction in regard to the bar exam. Now, what we're going to cover today is a pretty basic topic, torts, something that you've all had, obviously. And I want to talk in general, not only about the specific topic of torts, but a few different ways to think about bar exam essays in general, and some ways to really think about construction, IRAC writing, issue spotting, and particularly analysis. Now, in order to watch this lecture, the most important thing that you can do is to complete the exam assignment that's been provided to you if you're a Delaware Law School student. And what we're going to do is we're going to cover the 2019 torts essay. Now, if for some reason you're unable to locate that, you can Google it. It's available on the internet. And it's a good example of a question that poses a really narrow problem, but it also talks a little bit broader about the ideas of how we're supposed to approach essays with all the things that we've learned over the course of your law school career. Now, the most important thing when it comes to essay construction, and particularly the idea of how to approach the bar exam with a limited amount of time and a lot of information that you have to think about when you're going in, is that I'm going to cover three main things when we talk about this essay. We're going to talk about issue spotting, rule development, and analytical application. Meaning we're going to talk about, can you see the problem? Do you know what it is that the problem's focused on? But do you also know how to approach it in the context of what the bar exam is looking for? For rule development, are you including a necessary amount of rules in the scope of the problem that's being presented to you? And then what I think is a really important thing that often gets underutilized is analytical application. Are you applying the law to the facts to show that you understand how things operate? Now, at this point, I want to talk specifically about what I think the bar exam does, and maybe in a lot of ways, maybe what the bar exam doesn't look at in regard to maybe what I think you might be afraid of in regard to the context of what we're actually doing. Now, in the questions that I've had with students, the number one thing that I think people worry about is memorization, right? How am I going to memorize all this law? How am I going to apply the law? How am I going to get the answers right? You know, I think in general those are important things. I don't want to discount the idea that like memorizing law is hard. Getting the answer right is obviously important. But the most important thing I think when you think about the bar exam is are you informing the examiner that you are ready to practice law? Are you acting like a lawyer when it comes to the problem? Now, I'm not going to give away the essay in a bit. We're going to go over it. What I'll probably do is sort of like not stop and start, but kind of transition between the two different formats so I can show you all the available resources to give you an idea of what we're looking for. But before I jump into it, I just want to talk a little bit about how I think a lawyer might kind of approach the problem, because I think it's a little bit different in regard to thinking about how you might approach an exam question and how a lawyer is going to approach this problem. Now, this problem deals with two different issues, and we're going to go over the fact pattern, like I said, in just a little bit. The two questions are ultimately about a car accident. One is about the cause of the car accident. A man's driving with a woman. A woman's driving 10 miles under the speed limit in inclement weather, and he gets injured. Question being, can the plaintiff, hold the defendant liable based on her conduct? The other question is a little bit more long form. It covers a little bit more information, but it's essentially when the man develops complications after the accident, can he hold the hospital liable even though there's no real direct proof of how the hospital caused his injury, even though it's most likely? Now, many of you, right, I would argue almost all of you, can probably come to the right conclusion for both of these questions, right? I can answer them both in one sentence, right? The first one is, yeah, he can hold her liable if it turns out that driving 10 miles under the speed limit isn't something that a reasonably prudent person would do. Right, great. Second question is that the man can hold the hospital liable under the doctrine of res ipsa loquitur. Now, point being this, those are two sentences that do not show my ability to practice the law. They show my ability to understand the problem, and those are like MBE type analysis. Can you see the very narrow answer and give a really narrow point? The difference, I think, when you think about bar exam essays, really showing how to practice the law, is a few different things that are referencing I'm over here, information that I have up here. The idea of, can you see the problem? Can you approach it? Can you develop the correct law? And can you see the reasons as to why the law supports an answer? If I'm a lawyer and I've got the problem, the first thing I want to note is that I'm going to approach it from a few different perspectives. I'm going to go a small tangent here. When I first started practicing law, I worked at a general practice law office, and often people would ask me, what kind of law do you practice? And I would often answer it the same way that I would answer what kind of music I liked. I'd be like, well, I like everything but country music, right? I would say, I do everything but family law. Because when I started practicing law, family law was a little bit foreign to me, maybe a little bit scary, right? The problem with that analysis, right, when I say I'm going to do everything but family law, is that family law permeates everything that you do, right? I wanted to do criminal law, found myself in family court. I wanted to do real estate law. Well, you know who you own property with? You commonly own it with your family, right? So I found that like it's not easy to isolate one thing by itself. This is a point I'm going to bring up a little bit later, but when it comes to torts problems, I think thinking of torts not in the direct context of civil procedure, but thinking of it from the idea that if you're going to present a torts problem, you have to think of it from a procedural point of view. It's a plaintiff suing a defendant. Now, with that in mind, when you take the approach, thinking about this problem from the idea of how do you analyze all of the relevant problems, how do you make sure that you're approaching it, again, from a practical perspective. If I'm a lawyer, I have to know what that problem really means. Now, obviously, everybody knows what negligence is. It's duty, breach, causation, damages. When we talk about a person who's driving 10 miles under the speed limit, I think everyone can sort of note the idea that, well, is driving under the speed limit a breach of the duty? And that's fine. But when we talk about companion, looking at the problem from a few different perspectives, you can't really analyze breach of duty without also analyzing the duty part of it, right? Now, causation damage is also important, but those are two really key points as to why I provided the outline very specifically for this problem. Because it's not just narrowly focusing on one particular thing, but to show the broader scheme of it. Again, if I'm a lawyer, I have to know that those are the two main things that I'm going to have to prove to really win this case. I'm also going to have to show the idea that with those two issues, I'm going to have to show more rule development. I'm going to have to show more depth because those are the main points that I have to focus. It doesn't mean that I don't have to prove causation or damages, and those are probably going to be a part of whatever legal documents I prepare, but I know that's got to be my emphasis. And then finally, when it comes to analytical development, it's not enough to just tap the court on the shoulder and say, well, you know, I'm 10 miles into the speed limit, reasonably prudent person. You've got to prove all of the reasons why, and sometimes all of the reasons why not something is true and correct. And so, in general, when we think about bar exam questions, it's not just your ability to say, I saw the problem and I know the answer. It's a matter of really thinking about, are you able to express a really good understanding of how law is practiced, how a lawyer is going to approach the problem with a good amount of depth and be thorough with your answer. Again, the MBE is more specifically about knowing the answer and seeing the problem really specifically. This is a little bit bigger. And so in a lot of ways, we've already covered the answer. So congratulations, right? But the bigger point, I think, is that we have to look at it from a matter of, well, if we know the answer, how do we write about it? Right. Now, this here is going to be your torts question. Now, what you have here is a collection of a fact pattern, and at the very bottom, what you'll see here, I'm going to try not to scan too fast so nobody gets motion sickness. But essentially, what you see here are two questions at the very bottom that are very narrowly pointed with the word explain, right? I often think that when it comes to essays, the number one thing you want to do is read the question, obviously, first, read the question prompt. This is usually a little bit easier than when it comes to the MBE. Sometimes the MBE doesn't quite give you that really narrow focus that the essay questions do. But the key thing that you're seeing is that the questions are really specific, that they really give you a good idea of what you should be looking for and what your focus should be. When you go to the very top of the question, you'll note that there are two really big fact patterns or two really big components of the question. You've got first the cause of the accident, which is just like the very beginning part of it. You'll note that it's only a few sentences that really talk about the idea of how the accident occurred and essentially this component of driving under the speed limit. The other part that you'll note here when it comes to the hospital section is that there's a lot of content here and a really bunch of specific information. One of the things when it comes to thinking about specific information here is that this is the kind of information that you're using as a tool to prove your conclusion. This is not something you want to be restating verbatim. You don't need to tell the bar examiner the fact pattern back to them. They know the fact pattern. They're going to be reading a million essays about this. And so one of the things you want to think about is like, why is this information here? You know, in particular, when you think and you scroll down a little bit, you're going to see something. The physician told the man he must have contracted this infection at the hospital because the period between infection and system development is 10 to 13 days. And the man was a patient at the hospital during the entire relevant period. That's such a key sentence. It's such something that when you think about it, has to be relevant to the eventual idea of res ipsa loquitur, which once again we'll get to in a quick moment. But the idea there is that it's facts like that that you have to take really key notice of. Not because they exist, but what they mean in the future. In a way, I sometimes like to think of facts like this: of how does how does that fact follow the word because, right? I have a conclusion, the word because, that fact. This proves something else. And that's one of the key things when it comes to facts. You want to make sure that you're not citing something verbatim and assuming that your reader can make the connection for you. It's your job to make the connection using key language and making sure your conclusions are proven by all the facts available. Now, I have never been a highlighting person, but what I do like to do is write in the margins of the paper and being really selective. I know you don't have a lot of time when it comes to bar exam material, but taking your time and make sure you're able to specify the important facts from the less important facts is a really key component. Sometimes I also think it's a matter of, after you get a good idea of the question, taking some time, writing the rules, reading it over again, just so you kind of are able to kind of distinguish between things that might seem important in the beginning, maybe might be less so. So the issue here, when you look at the fact pattern, again, it's about a car accident involving a person driving under the speed limit, hospital where there's no proof. In both of these instances, you were provided an outline that really went over negligence, but only the first two components. Elements of negligence, once again, deal with things like duty, breach, causation, damages, but the focus here is really a matter of duty and breach. Now, in general, if I'm preparing an answer and I have a sample answer that I'm going to go over with you, the main things that I'm going to be looking at is that how do I address duty in a maybe lesser, more brief section, but something that really qualifies what the responsibility is that ends up getting breached after the fact, and then providing greater detail when it comes to the breach of the duty afterward. Now, one of the things I want to share with you, and this is my own personal experience, but I think that it was helpful, is that the idea when I approach the problem of duty that we see right here, the biggest problem I had was taking that paragraph and writing it in a rule section. That actually was the only thing that really gave me pause in the entire problem. And I bring that up only for this reason. It is easy to look at this. In general, a duty of care is owed to all persons who may be foreseeably injured by the defendant's failure to act as a reasonable person of ordinary prudence under the circumstances. I can memorize that. I can have flashcards. I can say that sentence right off the bat, but it doesn't quite establish what a plaintiff's responsibility is to prove that point. That sentence is objective. It isn't directed the way that I think the problem directs you to do so. And so one of the problems I have is, how do I finish the idea of a plaintiff's responsibility to prove duty is? And then I wrestled with it a little bit, which is one of the reasons why I think a key thing of preparing for the bar exam and preparation is memorization. But to me personally, I found that memorization was most effective with rewriting, crafting rule paragraphs and rule sections that consolidate concepts that you think might be tested routinely through the exam. Negligence to me is the kind of thing where I would go into the exam having a good amount of sentences just ready to go. I know what I'm going to write. I'm going to be prepared to do it. Because one of the things you don't want to do, and this is especially true for the bar exam topics that maybe you're a little less comfortable with, is you don't want to wait until the exam to write something for the first time. Be prepared, do it ahead of time so you can work out some of these kinks. Now, in general, when it comes to duty, when you look at some of these things here, you've got some content on foreseeability. Foreseeability is obviously important. But the thing is that you can't write all of this in general. You have to sort of pick and choose what's the most important and what might be something that you can paraphrase a little bit just for time and space and concerns. In this problem in general, I'm going to focus on including things that are important about duty, right? The reasonably prudent person, the responsibility of foreseeability and objectiveness. But I don't know that I'm going to cover all of the detail in general, because the problem here, I think, is more based on standard of care and breach of duty. The breach of duty is so much more important because that's really the issue here. The duty to drive safely, I think, is fairly clear, but the breach of that duty under the circumstances requires a little bit more of an analysis. So once again, I'm going to look at this problem and I'm going to take the approach of, this feels fairly standard to me, right? Whether driving in that way breaches the duty that you're responsible with. Now, I bring that up an important component because you were provided two other sections. You were provided negligence per se and res ipsa loquitur. Now, res ipsa loquitur is something that I actually don't think is applicable in this part of the question. It's more applicable in the hospital part of the question. Now, in many instances, when provided with material, I think it's very reasonable for students to say, well, if it's here, I should be using it. But the problem with that is that res ipsa loquitur, I don't actually think is that relevant to this problem. Now, in general, if you can make an analysis and you can qualify why it's not there, I'm sure that's perfectly fine. But I also think it's somewhat of a waste of time and it's a waste of resources to address something that's so clearly not applicable. By way of contrast, I think the discussion of negligence per se is worth discussing, but to qualify why it doesn't apply, meaning that I reference negligence per se just very briefly to note what it was and that driving under the speed limit is not a violation of the statute, and therefore negligence per se wouldn't establish the same standards. The idea here is that you want to sort of have a good idea of where do I draw the line between something that's relevant and can get me some points and maybe not relevant and is just sort of a waste of my time. In my opinion, I think the approach for the first question is more a matter of breach of duty negligence per se. The second question is mostly a small discussion on breach and a greater discussion on res ipsa loquitur. So the point here being balancing the point of where do I cover a lot of material? Where do I find the balance? There's no hard and fast rule here, but I think when it comes to rule development, I want to convey to the examiner that I know the standard, I know how a lawyer will approach the problem, and I've got a good amount of depth that I can also work with. A good amount when you think about in general, where should I think about my rule development is really two key facts. I think you want to think about defining the concept, but also defining how to prove the concept. A good example here is when we talk about standard of care. That standard of care is that of a reasonably prudent person. Great. But how you prove reasonably prudent person is that it's objective, right? It's what a reasonable person would do rather than what a particular defendant is acting in good faith or using best efforts. That distinguishment is how lawyers prove things. So your ability take that standard and say, I'm adding a few extra sentences to give a little more depth to my rules that I can then apply to my rule application, I think is really important. Coming back for a quick second, I want to take a small pause going back to the material. I'm going to show you a sample draft that I had done just for a few reasons when we talk a little bit about how things are put together. But I think it's important to note that, again, we talked about issues, talked about rule development. Application is another part that I think is deceptively difficult, especially when you are in law school, leading up to bar exam, leading up to practice. Meaning that the idea of breaking some habits when it comes to thinking about that application section. How do you prove your conclusion? How do you use the facts effectively? The main thing when it comes to application and analytical analysis of the law is I think two main things you want to both have and what you don't want to have. The key thing of what you want to have is a symmetrical analysis of the law, meaning that every sentence in your rule section, you have a comparable section in your application section. So thinking of it from a matter of wherever I start here, that's the next sentence I'm going to do at the bottom, and that you have something mirrored in a certain way, meaning that you make sure that every rule is covered, right? And every fact has a connection back to the rules just the same. The other thing to remember is that the word because is your absolute best friend, right? Everything is because. Every conclusion follows because. Making sure, in a sense, that the thing you want to avoid more than anything, and a suggestion I might make after watching this video when you read your, go back and read your exam again or your submission, is like in that paragraph where you're justifying your conclusion, how often are you using the word because? Do you have legal conclusions that don't have the word because and stand on their own? Do you have statements of facts that don't have any legal conclusion compared to them in general, right? One thing that I look for, especially when I grade first-year law students, is something I like to call a conclusion sandwich. Is a Professor Bendistis original, thank you very much. This is the idea where you start your first sentence of your paragraph with your legal conclusion. You list all the facts back in the fact pattern, and then you end with a legal conclusion. Now, the problem I have with that is it's like sort of going to a restaurant and then being like, well, here's your milk, here's your flour, here's your sugar. The griddle's in the back, have fun making pancakes. It's like, no, I'm here for you to make me dinner, right? So the idea, because I eat pancakes for dinner often, is that like it's your job to make the analysis. You've got to draw that conclusion to show that it matters. So once again, going back to the idea, it's easy to say this defendant breached her duty driving safely by driving 10 miles under the speed limit. It's about why, right? Why would a reasonably prudent person's standard support that idea? Why is it objectively true? Why does the weather matter? Right? Why does the speed limit not matter? It's all these things that I think are important of taking the facts and thinking of it creatively. Very often legal writing isn't creative in the sense that you're like this lyrical dance. It's sort of like a blunt object in many ways, but a lot of the creativity comes from the idea of thinking about the why, right? Thinking about why your answer is correct. I recognize you don't have a lot of time, but in a lot of ways, I like to think about why am I correct? And why are other conclusions incorrect? And those is really the approach on all available questions, making sure that everything's proven and that you're showing that you've covered everything that you need. Because again, the main thing about practicing law is making sure that you're approaching a problem and seeing all of the ways that you need to establish your case. Now, I'm going to go back and we're going to cover a sample answer. I'm going to talk a few different things about what sample answers should have, and how to really think about your writing in a grander scheme of things. So this is my answer to the same question, and I want to note a few things at first that I think are important to note. So for question one, what you'll see here is I have three individual paragraphs that are fairly clear. I'm going to go into the individual section of what they both mean. For the second question, I have two primary paragraphs as well. The main thing that I strive for when I think about writing bar exam questions is that every paragraph has a purpose. When you think about when you're reading cases, Supreme Court, Superior Court, Court of Common Pleas, whatever, every paragraph has a real goal to it. It covers one main topic in a really particular, important way. I like to write the same way, specifically if I have the availability of writing something on a computer. Now, many years ago when I took the bar exam, I wrote it by hand, right? But I try to think of the same way, meaning that when I approached a paragraph, I thought of doing it in general that I would have one main idea for every paragraph. And when possible, I would try to make sure that my IRAC analysis was in one main section. Now, there are times where I think it's worthwhile to think that you can have an issue, rule, and application conclusion in the next section. But in general, with bar exam content, especially if you don't have a lot of time to write, I think it's okay to consolidate and make sure that your answers are in one main section so that the examiner knows where every topic is. What you're going to see in question one is that I have my duty paragraph first, I have my breach paragraph second, I have a short paragraph here on negligence per se at the very end. Now, in general, I also will note that every single paragraph has the exact same structure. My first sentence addresses the issue. My next few sentences address very specifically the rules. And then after that, I have my application sentences afterward. Every single paragraph is going to look that way for me, no matter what. I'm not going to deviate from that. That way, every single one of my paragraphs looks exactly the same. Now, I've been a professional writer legally for many years. It's like my priority, it's my bread and butter. But I have generally found that no matter the topic I have, if I stick with IRAC form, I never go wrong. I think the bar exam's the same way. Meaning that if you find that your writing is deviating from from an IRAC specific form, I think you have to think about an idea of how are you presenting the answer. In general, when you think about, again, each of these paragraphs, I'm not going into an incredible amount of depth, but I'm also making sure I'm representing what's important about each issue. Like I said before, I found that the crafting of the duty standard was difficult, right? Plaintiff must prove duty, breach of duty, causation, damages. And the idea here is, can it be established? That's the main point that we have here. So I wanted to make sure I could phrase it in the idea of what the plaintiff had to establish and what they had to prove. I have three sentences that give me an explanation and then the procedure of how that standard is really put into practice. You'll then note here I have two application sections, a strong point of because, but the main idea of my application sections is that I am conclusion first, facts second. That's a key thing when we think about application, is that don't build to your conclusion, state your conclusion, give your explanation after the fact. I recognize the idea that it may seem obvious in many circumstances, but making sure that you're qualifying all of the applicable reasons as why something's true is an important part of proving that you're able to practice the law. If you note even here on the breach paragraph, I know this is important. I know this is the main point of the question and what the bar exam wants me to get to. So the idea here is that I could have obviously resigned the fact at the first sentence. You could breach the duty of care outlined above under both standards, even if you were driving under the speed limit. But that's not what the question wants. The question wants your ability to not only see the problem, but to also be able to explain it with a lot of good detail. So here I have conclusion first, facts second. And so I've taken what is essentially a very narrow question And I've really explained from a legal perspective all of the different ways that something can be proved. From a symmetrical point of view, I'll also note the fact that I have my two different standards, right? I have first the reasonably prudent person standard. I have the second standard that's outlined in my outline. My application paragraph or section mirrors that standard. I go the first part first, all three elements of the second section after that. Now, again, you may not have a whole lot of time when it comes to actually doing the bar exam. So you have to sort of prioritize what's the most important point. I think in general here, the priority here is not being verbose with your facts, making sure that you're giving, again, conclusion, explanation, and making sure that you're giving the bar examiner a good idea that you understand the problem. You'll also see here at the very bottom, I have a very short paragraph on negligence per se. I like to think of this as a matter of it's just me checking the box, right? And what I mean by that is that there's a, there's enough to negligence per se why I think it's important to note like why something could maybe not be the answer along with being the answer. Sometimes I found when I would practice the law, I would be posed with a problem that generally seemed like something I could recognize, but when I looked into greater detail, it would obviously not be applicable. It's a very reasonable thing to think. I think in the idea of thinking about negligence, car accidents, speed limits, it's worth noting the idea of qualifying why something could be true and maybe some reasons that may not be as applicable to once again evidence your knowledge, show that you're being complete, show that you understand the law. For me here, it's a simple one. It's not negligence per se because there's no proof of a violation of the law very specifically. Now, if you believe driving 10 miles under the speed limit is a violation of the law, I think that's fine. Then include that, right? But the point being is that don't just prioritize one very specific answer. Prioritize conveying your knowledge in a way that makes the most sense. Now, I want to note here in the same question regarding res ipsa loquitur, I'm going to give the same exact duty analysis. I'm going to use the same sentences. You don't need to reinvent the wheel. If it works in the first one, it should work in the second one. I'm also tailoring my application paragraph to what my answer is going to be eventually, talking about the responsibility of hospitals not to give people blood infections, but also making sure that you're cleaning and sterilizing your equipment. Same thing here with the application. You'll see this is a substantive paragraph that gives me a conclusion, the facts, conclusion, facts. You have first, second, third. There's organization, there's structure, and there's symmetry to make sure I'm covering all the things that are most necessary. Once again, the thing that you're not going to see is just a very rote explanation of what happened and that there's organization. The key thing that I always try to prioritize is to make sure that if somebody wants to know what my answers are, they know very specifically, they know where I know the law, they know where I'm giving conclusions, and they know where I'm analyzing the problem. So a few points I want to talk about in general here. Again, broad picture. I know I gave away the answer to the problem, but I also want to note the idea that this essay is more about, well, I'd say it's less about just knowing the answer or memorizing the law, but it's also presenting your knowledge, right? Bar exam is not about what you can memorize. I'll tell you that as a lawyer, I do not memorize any law, right? Very specifically. I don't have the same knowledge memorized that I had going into the bar exam because essentially now if people ask me a legal question, not a lawyer question, I just go research the answer, right? And so the idea there is that memorization of the law is not the only thing you're doing. It's about analyzing problems, being able to show that you're able to convey your knowledge in a clear manner that, again, is consistent with the practice of law. The main thing I want to note here is that when we talk about writing tips, I just want to go back and note the fact that it's about writing in a clear and concise manner, using good, clear paragraphs to convey what you're doing, and then writing in full and complete sentences throughout everything. Now, I'm going to post this answer to your Canvas page. And the number one thing I want to think about is that when you read that, don't think about it from the context of a right or wrong answer. Don't think about it as, I had the same thing he did, so I'm good. It's more about, I think, of the idea of thinking about style. And you can't plagiarize style, right? Style is so important. One time someone told me this, and as a musician way back in the day, right, is that if you want to learn how to be influenced by somebody, you want to be good at like playing guitar, you copy somebody else very specifically, and you go from copying them to being influenced by them. Meaning that if you really like John Mayer, right, if you want to play like him, you copy him for a pretty long period of time, and then as you get better at it, you're influenced by John Mayer. You're not copying him anymore. Now listen, I'm not saying I'm the John Mayer of legal writing, right, between you and me. But the point is that if you copy the style in which I write, you take sentences out of it, use the exact same structure, and not even me, anybody, right? you're going to be able to emulate something that passes the bar exam later. And so when you're looking at these answers, I don't want you to just focus on like, oh, I saw that problem and I have the same conclusion. I want you to think about the idea of, does yours look like mine? Right? Does yours look like any of the other samples that you've been given? Not the rubrics, right? But the samples. Those are the key things I want to think about, because I think a lot of people think they're going to pass the bar and possibly don't, because they're looking at it from the matter of, did I memorize the law? Did I get the right answer? And I want to think a little bit about in these early stages of getting prepared for the memorization of the law, is your form right? Is your content right? Because that can be a big component of what you're thinking about. When it comes to legal tips, I also just want to note the idea of memorizing sections is a big deal. But one of the things that we talked about, at least from the other section, is that, duty had these very few subsections. Breach had those three subsections. One thing when I think about rewriting the law and how to memorize it is just writing about, like, what do I need to remember with each section, right? Like when I approach a negligence problem, I know duty deals with foreseeability. Breach is what I generally think to be breach, but that there are subparts about negligence per se and res ipsa loquitur. I recognize the idea that elements will come with it. There's so much material to remember. But what I used to really like doing is rewriting the outlines so I would remember those subparts, how things go together and how to think about it. The other thing that I would also note is that you may run out of time here. I felt that in my personal experience, and this was a while ago, I didn't run out of time in Pennsylvania, New Jersey, but the best thing that I did in Delaware is that I took the bar exam the weekend before at my kitchen table. Not this kitchen table, but a different one. And what I realized was that it was fast. I felt like I was rushing to get through every single question. And so one of the things that I realized is that I couldn't spend the amount of time that I used to spend in law school classes, where I would commonly be the last one to leave, just because it was too fast, right? And I often find that, if you don't answer questions, you're really putting yourself at a point disadvantage. And so one of the things to think about is like, what's the main issue, right? You see that problem, you go, I know that's a breach issue. I think it's worthwhile, at the day of the bar exam, to address all of the ancillary issues, but sometimes you can't give everything the same amount of weight. Duty and breach, very key, right? Causation damages, a little bit, right? We didn't give you the material here for this question, but I think it's worthwhile to note that, like, causation's black and white, right? You have that sentence ready to go. But for causation, proximate cause, I have it. Damages, he's got the $100,000, $250,000. It's just there just in case. I think it requires you to be a little bit more thorough with your analysis. But again, it just shows the idea that you're thinking of everything in really clear, regimented paragraph forms. That's the thing that we want to do more than anything. Now, over the course of the next semester, we're going to go over a few other problems like this. I'm going to record more videos like this, because at the end of the day, it's a multi-part process of passing the bar. It's not just memorization. It's just not learning new topics, but it's thinking about the idea of, am I presenting the material in the way that best exemplifies what my knowledge is? Now, as always, you can see my email address is right here. It's bebendistis@widener.edu. If you have any questions in general about anything regarding this video or anything regarding the bar exam, please email me. I'm more than happy to help up through the bar, even after the bar. You can also look at more videos like this on my YouTube channel, which if you put my name into YouTube, you can also check out my podcast, which is Citizen's Guide to the Supreme Court, which covers Supreme Court cases. I will be back with more videos like this through the rest of the spring and the summer. Good luck. Thank you for completing this question, and I'll see you again soon.